Detailed summary of the Karnataka Sakaala Services Act, 2011 and its amendments. Introduction. The Karnataka Sakaala Services Act, 2011, amended in 2014, is designed to guarantee timely delivery of services to citizens in Karnataka. This legislation, known officially as the Karnataka Guarantee of Services to Citizens Act, ensures that various public services are provided within a stipulated timeframe, with provisions for compensatory costs if there are delays. Key provisions of the Act. Short title and commencement. The Act is officially titled the Karnataka Guarantee of Services to Citizens Act, 2011. It came into force on a date specified by the Government of Karnataka through an official Gazette notification. Definitions. The Act defines key terms such as appellate authority, citizen-related service, competent officer, designated officer, government, local authority, public servant, right to service, schedule, and stipulated time. These definitions clarify the roles and responsibilities of various officials and the types of services covered under the Act. Right to obtain service. Citizens have the right to obtain specified services within a stipulated time as mentioned in the schedule. Designated officers and their subordinates must provide these services within the specified time frame and display the details on their office notice boards. Notification of services. The government is required to notify the services, designated officers, competent officers, appellate authorities, and stipulated time limits within 3 months of the Act's commencement. These notifications can be amended to include new services or modify existing entries. Provision of services. The stipulated time begins when a duly acknowledged application is submitted. Designated officers must provide the service or reject the application with written reasons and information about the appeal process within the stipulated time. Monitoring and e-governance. Citizens are given application numbers to monitor the status of their applications online. Public authorities are required to maintain and update the status of applications online. The government encourages the adoption of e-governance for timely service delivery. Compensatory costs and liability. Citizens are entitled to seek compensatory costs if there is a delay or default in service delivery. Designated officers or their subordinates who fail to provide services within the stipulated time are liable to pay compensatory costs of 20 rupees per day, up to a maximum of 500 rupees per application. Competent officers are appointed to impose these costs and ensure timely service delivery. Appeal process. Public servants can appeal against orders imposing compensatory costs. Citizens can appeal if their applications are rejected or services are not provided within the stipulated time. The competent officer and appellate authority have powers similar to civil courts for resolving these appeals. Developing a service-oriented culture. The Act emphasizes sensitizing public servants towards timely service delivery rather than punishing delays. Habitual and willful defaulters among designated officers can face disciplinary action. Efficient officers may receive letters of appreciation to be noted in their annual performance reports. Legal protections and rulemaking. Actions taken in good faith under the Act are protected from legal proceedings. Civil courts do not have jurisdiction over matters decided by the competent officer or appellate authority under the Act. The government has the power to make rules to carry out the purposes of the Act and to remove any difficulties in its implementation. Amendments in 2014. E-governance. The amendment promotes e-governance, encouraging public authorities to deliver services electronically or through post, as prescribed, potentially subject to fees. Compensatory costs. The liability to pay compensatory costs is extended to appellate authorities, competent officers, designated officers, and their subordinates, with the same rates and conditions. Updating HRMS software. After compensatory costs are paid, competent officers must update debit notes in the HRMS software against the guilty officers within 30 days, following principles of natural justice. Disciplinary actions. If an officer fails to deliver services more than 7 times, they are subject to an inquiry by the disciplinary authority. If found guilty, A report is submitted to the government, which must take action within a month. Conclusion. The Karnataka Sakaala Services Act, 2011, and its amendments aim to enhance the efficiency and accountability of public service delivery in Karnataka. By ensuring services are provided within specified timeframes and introducing compensatory costs for delays, the Act strives to create a more responsive and citizen-friendly governance system. If you liked all these points, please like the channel and share it with your friends. More good information about service matters will be brought to you in the future. Endless thanks to you for listening to this voice message.